Delivery of judgment, item 35 from supplementary list.
May I please your lordship? I beg to.
For reasons mentioned in the judgment, the appeal is dismissed.
Obliged.
May I please your lordship? With consent of the other side, I beg to mention item number 19. Kindly release the matter after due vacation.
What is your name?
B. Sharma on behalf of M. Talukdar.
Miss D. Sharma, learned counsel for the. Your counsel for appellant.
Yes.
Learned counsel for the appellant. Who prays for an adjournment. She submits that she has informed learned counsel for the respondent regarding her pair, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after view vacation on a date to be fixed by registry. Yes.
Right, may I please your lordship? I beg to mention one item, MSC Appeal 672 of 2017. Lordship,
Total
the
date.
parties
Yes.
have amicably settled the dispute and have agreed for a joint compromise. Lordship, I kindly request the matter to be listed on 27 March for compromise.
Okay. Okay.
May please your lordship, I beg to mention item number 21 with the consent of the other party. We adjourn the matter for today and fix the matter after view vacation.
What is your name?
P. Bodloy for K. Bhattacharya. Respondent.
Miss P. Bordole appearing for Mr. K. Bhattacharya. Bhattacharya, respondent number 1. Learned counsel for respondent number 1. Who prays for an adjournment on with the consent of learned counsel for the other side. The prayer is allowed. Let this matter be listed after view vacation on a date to be fixed by registry.
May I please your lordship? I beg to mention for listing some urgent 4 matters, lordship, CRP lordship, for orders column.
2nd April.
Obliged.
May it please your lordship. Item 26, my friend is also here. My lord, I am friend for taking up the matter on in the first week of May, my lord. It may be on 5th of May, my lord.
Heard Mr. M. R. Khondokar, learned counsel for the appellant who seeks an adjournment. Also heard Miss P. Haldar, learned counsel for the respondent who does not raise any objection. The prayer is allowed. Let this matter be listed on 5th of May.
I am the.
May I please your lordship? I am here to mention item number 14. Please adjourn the matter for today and kindly fix it after view.
Lordship, 28 April.
28.
On request,
Item 14.
1-4.
Yes, your lordship.
1-4.
What is your name?
Ms. Didash on behalf of Ananja.
Heard Miss D. Das, learned counsel for the appellant who seeks an adjournment. Also heard Mr. R. Chetri, A. Chetri, learned counsel for the respondent who does not raise any objection. Let this matter be listed on 20th April.
May I please your lordship? I beg to mention item number 22, my lord.
22.
22, my lord. The other side is here, my lord. So the matter may be adjourned, my lord. And the date may be fixed, any date as per your lordship's convenience prior vacation, my lord. Because on the last occasion also matter was not because of the portion.
Prior to vacation, is it possible? It may not. It may not be possible.
Immediately after vacation then.
Okay. Heard Mr. B. K. Das, learned counsel for the respondents. Item number?
Item number 22. 22.
You are for the.
I am for the respondent. He's for the appellant.
Okay. Also heard Mr. R. Goswami, learned Me B.K. Das, learned counsel for the respondent who seeks an adjournment. Mr. R. Goswami, learned counsel for the appellant, does not raise any objection to the prayer made by the learned counsel, hence the same is allowed. Let this matter be listed on 23rd of April.
May I please your lordship? Lordship, I beg to mention for listing on MSc appeal lordship for motion. Any date in next week, lordship. There is some reasons.
2nd April.
Let me, Lordship. I beg to mention one matter, MSc appeal for listing, Lordship.
When,
The matter was fixed on 19, considering
when
the
do you want?
26th,
26 possible,
70% disability,
27.
27th. Not nice.
Lordship, I beg to mention item 9 and 10 of today's hearing is my plain appears for the respondent. Herein, Lordship, Mr. B. Sharma appears for the appellant in item 10 and Mr. G. Goswami for the appellant in item 9. I appear on their behalf, Lordship. I am praying that this matter may be taken up in the first week of, if possible, April, Lordship.
Your lordship may fix the date as it.
Heard
Sir.
Mr. Separate orders of, separate orders for 9 and 10. What is your name?
I am MP Sharma.
Heard Mr. MP Sharma, learned counsel for appellant,
Yes, Lordship. In
for
both the-
appellant who seeks an adjournment. Also heard Mr.
A Deb
A. Deb in
on behalf of D Rathi.
appearing on behalf of D. Rathi. Who does not raise any objection. The prayer is allowed. Let this matter be listed on 23rd of April.
Much obliged, lordship.
May I please your lordship? Lordship, as a listing of a matter, we have filed an IF in a MSc matter for withdrawal of FDR
When do you want?
on 31st of March.
Okay.
31st.
Okay.
Daily list, motion দিয়ে item 1.
May I please your lordship? Lordship, this is a second bail application, lordship, and the new ground is third charge sheet. The bail application file, third was framed, lordship, and out of 8 witnesses, lordship, 4 witnesses was examined, and PW4 is lordship informant was examined and discharged. Lordship,
What is the date of your arrest?
lordship, I was arrested on 26,
1 year only.
yes, 1 year.
What is the ground?
Lordship, new ground,
What is the new ground?
yes, so the new ground, before first bail application was filed, before charge sheet was filed, lordship. Now charge sheet was filed, charge frame, and out of 8, lordship, 4 witnesses are examined. PW4 is informant, lordship. 2 ground in this case, lordship, no conscious possession is there, lordship, and prolonged incarnation. Lordship,
Prolonged
what happened-
incarceration
Yes, yes.
will not help you.
Yes, lordship, what happened in this case is, lordship is dead. The petitioner mother was expired
Yes, Mr. K.
on lordship
My lord,
15.
Can this here maybe call for, my lord? So this is commercial quantity, my lord.
Yes, lordship, this is commercial concept, quantity, lordship. I have a, lordship, I have a prayer for interim bail, lordship. What happened in this case, lordship, petitioner mother was expired on 15 March, lordship. And, lordship, I mentioned in para, lordship,
15th March.
15 March, lordship. And Sadhu ceremony was 29 March, lordship. Only for 3 days, lordship. Interim may be granted only for 3 days, lordship, to attend the Sadhu ceremony of his mother, lordship. Only for 3 days, lordship.
Yes.
Only, my lord, 37, reward of 37. Otherwise, my lord, I don't have, my lord, that in this regard, my lord.
How much?
My lord, here, my lord, 30.85 kg ganja.
Yes, yes.
Where is the material to show that regarding Shraddha ceremony? Any document?
Lordship, when I filed this bail application, lordship, mother was admitted. She was suffering from cancer, lordship. Now I have the power certificate. I can.
Death certificate is there.
No, that certificate not there because they cannot apply it right now, Lordship, but.
Abura certificate certifying death,
Yes, Lordship.
certifying the death.
Yes.
Yes, Mr. Bosho. For,
To attend the ceremony.
when is this Shraddha?
Lordship, 29 March.
Where is the statement? You have made statement.
No, Lordship, because when I filed this bail application, Lordship, mother is alive. Now, after this application, Lordship, impending.
You file an application. Bringing on records.
Yes, Lordship, tomorrow
Tomorrow you file, we'll consider.
It's a matter on 22nd.
No, tomorrow you file, we'll decide the interlocutory application tomorrow itself. Now we are
Yes.
calling for
Yes.
the scan copy of the records. Heard Miss, what is your name?
K. Malako, Lordship.
A. Malakar. K.
K.
Malakar,
Malako.
learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. This is for the second time the petitioner has approached this court seeking bail. His earlier bail application was dismissed before filing of the charge sheet. The petitioner is languishing behind the bars since 26/3/2025. Perusal of the scanned copy of the trial court records as well as the connected case diary would be necessary. Hence, call for the same. Call for the same. Registry to take steps for requisitioning the scanned copy of the trial court records as well as the scanned copy of the connected case diary. Let this matter be listed on 24th of April. Learned counsel for the petitioner has submitted that during the pendency of this bail application, the mother of the petitioner has expired and he is required to attend the Shraddha ceremony of his deceased mother. She submits that the petitioner may be allowed to file an interlocutory application for making the said prayer. The petitioner is at liberty to file any interlocutory application.
Lordship, for interlocutory application, Lordship, can it be fixed on 27?
No, you file tomorrow.
Tomorrow, yes, I file tomorrow.
We will not, if you file tomorrow, you make a mention and bring it. We may consider it tomorrow or day after tomorrow,
Okay.
list accordingly.
Okay, please.
To record to Rakhi.
May I plead your lordship, this is regular bail application, allegation under section 22C and 29 lordship. Petitioner behind the bar for 160 days lordship. Charge has not submitted lordship.
Pending investigation. We'll call for the case diary. Heard Miss R. Deka, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the same. When, Mr. Bosho, let the matter be listed.
Lordship short date may
Sure.
160 days already.
No, short date. Within 20 days.
After
8th of April.
8 of April.
Admission, item 3.
That will also.
Before my friend starts,
Yes,
I have a preliminary objection to maintainability.
yes.
Your lordship can consider that or perhaps after
Maintainability of
the appeal.
this appeal. Okay. What is this appeal?
Well, this is an appeal. First appeal, my lord, under section 37(1)(b) of the Arbitration and Conciliation Act 1996 against the impugned judgment and order dated 17/2/26 passed in Miss Arbitration case number 205/24 by the Court of London Civil Justice Senior Division number 1 at Gauhati upon application filed under section 9 of the Act of 1996.
Where is your memo of appeal?
In memo of appeal, book number 1, my lord. Book number 1. There are two books. Book number 1, my lord. Memo of appeal.
Putul, one more. Okay.
Volume 1 is the comparative memo of appeal. Volume 1.
Okay.
It starts from page 1, my lord.
No, just a minute. You have annexed the impugned judgment at the
Yes,
top.
my lord. Have an explain.
Where is the memo of appeal after the impugned judgment?
No, my lord, in book 1, my lord. At the top, my lord, this is memo of appeal.
Which one is book 1?
There are two volumes, my lord. Second volume starts from page number 485.
I'm not getting the memo. No, this is second volume.
Volume 1, volume 1.
तो क्या उद्योग का memo of appeal to be सारी दी. Flag it. That is what I am asking. If you annex the judgment
Yes, my lord. I have an next, my lord.
before the appeal,
That's why.
how I will find out?
So, my lord, that is
Your page number 1 starts from the middle of volume 1.
page 1. It starts, my lord, in volume 1, my lord. After four pages, my lord. 4 pages are the list of annexures, my lord, and synopsis, my lord. Thereafter, memo of appeal starts.
Okay. Yes.
This memo of appeal starts from page 1, my lord.
Where is the impugned order?
Improve order, my lord, in volume 2, my lord. Page, my lord, 726. At the last portion of the volume 2, my lord. Initial 14, my lord, page 726.
Yes. Make your submission.
My lord. My lord, here in this case,
I'll come to you before.
my lord, present respondents, principal respondents, my lord, have filed an application under section 9 of the Act of 1996 before the London Trial Court, seeking for interim measure of protection, my lord. That is, they start from page 38, my lord, of volume 1. Page 38. Annexure 1.
Yes. Yes, you tell me the brief.
Yes, my lord. My lord, your lordship may come to see page 43, my lord, of their application. Page 43, my lord, para 1 of this application.
Yes. This is your application.
Application of the principal respondents before the trial court under section 9.
Okay.
Para 1, your lordship.
Yes.
Para 1, my lord, the parties to this proceeding have been involved in various business houses, entities in the form of registered partnership firm, limited liability partnership, and private companies, and also are collectively referred as the Protect Group. The same is the close-knit group comprised primarily of the members of the two families, being single family and the Jalan family. Well, this is an admitted position of fact, my lord. In respect of the business entities of Protect Group, there are two families, my lord, single family and Jalan family. Single family is the major stakeholder in the entire business entity, my lord. My lord, in the month of May 24, my lord, the present appellant number 1 has found that the respondent number 2 has been involved in siphoning the funds of the respondent number 1 while doing the similar and identical business activities in the name and style of Ambika Group.
Yes.
Then, my lord, he had filed an application before the bank, which holds the accounts of the entire business entities to freeze the account, my lord, not to allow the respondent number 2 to operate the bank account. Then, my lord, it was freezed. Bank account was freezed by the banker. Immediately, my lord, there was proposal for amicable settlement of the disputes, my lord. Then, my lord, on presumption of amicable settlement and partition of the business entities between both the families, my lord, appellant had allowed the respondent number 2 to operate the bank account temporarily for the time being, my lord. This is an ability position fact. And my lord, share of the appellants, my lord, in the partnership firm is not in dispute. They are the shareholders, major stakeholders in the partnership business, my lord. Thereafter, my lord, after prolonged negotiation of almost 3 months, my lord, a mutual settlement agreement was signed by respondent number 2. That may kindly be seen, your lordship. Annexure 6, page 485 of second volume, my lord.
Page number.
Page, my lord, internal page 493. Second volume, my lord.
Yes.
Page 493, my lord. This
Yes.
was the MSA, my lord. This was executed by own hands of respondent number 2 and 3, my lord, on 23/9/24, my lord, in presence of mediator. And my lord, by virtue of this document, my lord, the business entities have been separated between Jalan family and single family, my lord. And my lord, respondent number 1 entity, on the basis of which, my lord, the section 9 application was filed before the trial court, was in totality given to the share of the respondent number 2 and 3. Jalan family, my lord. This was MSA, my lord. This was not signed by respondent number 2 and 3 by their own hands. My lord, this is not under challenge till now. In spite of signing this MSA, my lord, mutual settlement agreement, my lord, and separation of their business entities, my lord, for last 3 months, my lord, respondent number 2 and 3 have not come forward for releasing the shares fallen in favor of the appellants, my lord, pursuant to this MSA. Then, my lord, the appellant number 1 had written a letter to the bank Your lordship, I cannot see. Lordship, I cannot see annexure 12. That is at page 112. of volume 1, my lord.
Page number?
Page number 122 in Extra 12. 122, 122.
Yes. Yes.
Page 122, my lord. This was later, my lord. My lord, after 3 months of signing this MSA, my lord, this letter was given, my lord, by the respondent, claim number 1 to the banker. My lord, your lordship can see page 123, last paragraph. Page 123, my lord, last paragraph. Because, my lord, in spite of signing this MSA, respondent number 2 and 3 had not acted in pursuant to this MSA, my lord. Then, under compulsion, the appellant number 1 has written this letter to the banker. Page 123, my lord, last paragraph. I request you to order for review and audit of all the signatures, KYC to be redone of all the bank accounts to resign the check signing authority.
According to this mutual settlement agreement,
My lord.
what was ought to have been done by?
My lord, by virtue of this MSA, my lord, the Pride Realty, respondent number 1, on the basis of which, my lord, section 9 application was filed before the trial court, was given in totality in the share of respondent number 2 and 3, Jalan family. And pursuant to this MSA, other business entities are required to be given to the share of the appellants, my lord.
Okay.
Without taking, my lord, 100% of respondent number 1 entity, my lord, they have filed application under section 9 of the Act of 1996 before the trial court and obtained expediting injunction order, my lord. And since, my lord, 19/12/24 till date, this section 9 application was filed suppressing this MSA, my lord, and obtained expediting injunction order on 19/12/24. Since 19/12/24 till date, entire bank accounts of Protect Group has been operated by respondent number 2 single-handedly, without any intimation, without any disclosure to the appellants, my lord. Share of the appellant in the partnership firm is not in dispute. That, my lord, under compulsion, this letter was remitted to the bank, my lord, requesting inter alia to update the KYC for assigning the check signing authority. Because, you know, as per partnership section 12 of the Partnership Act, each and every partners are having the right and liberty to take part in the operation of the bank account. Section 12 of Partnership Act. But, my lord, this was not complied with by the respondent, my lord. They single-handedly went on operating the bank account, my lord. Then, my lord, this letter was issued to the bank for verifying the check signing authorities and to update the KYC. KYC, my lord, is not at the option of the parties to this litigation or at the option of the bank, my lord. This is the RBI guideline. And as per RBI guideline, my lord, bank is to comply with the KYC, my lord. Just to, my lord, which has been initiated by the RBI for preventing the money laundering. Here in this case, strictly, money laundering has been effected because, my lord, the funds of this Protect Group has been siphoned by respondent number 2 to his own entity, my lord. Similar and identical entity, Ambika Group. This is also not in dispute. No way there is denial that Ambika Group, similar and identical, my lord, business activities not belong to respondent number 2 and 3. Pursuant to this, my lord, bank has freezed the bank account. Although, my lord, there was no prayer for freezing the bank account. Prayer was made by the appellant number 1 for updation of KYC and to ascertain the check signing authorities, my lord.
Thereafter?
After this letter, my bank has freezed the bank account. After that, my lord, they have filed section 9 application, you know, got the account opened by virtue of interim order dated 19/12/24 by the trial court. Expediting injunction order. Wherein, my lord, AMSC dated 23/9/24 was suppressed.
Ex parte order dated
19/12/24. Passed in this arbitration case number 205/24.
Thereafter?
Thereafter, my lord, the present appellants had appeared before the trial court, filed their objections, and, my lord, this objection, this matter could not be decided within 30 days, my lord. Then, my lord, the present appellants had filed application for modification of the order dated 19/12/24, my lord. That was also not decided, my lord, at the earliest possible, my lord. Then, my lord, the appellants were compelled to approach this court, my lord, for early disposal of their application. Both the applications, section 9 application as well as modification application. Thereafter, my lord, matter was disposed of by the interim judgment and order dated, my lord, 17/2/25/26. After almost 14 months, my lord. And by virtue of this impugned order, my lord,
This
it-
17,
17/2/26.
this is the impugned order,
Impugned order, my lord.
by which section 9,
Allowed in totality.
okay.
Allowed in totality, my lord. Without assigning any reason thereof, my lord, without considering the facts pleaded before the trial court by the appellants. Has this appeal, my lord? This is an appeal, first appeal, my lord. This honorable court, with all respect and regard, my lord, being the first appellate court, is the last court of facts, my lord. So appeal is required to be admitted for hearing, my lord.
What is the maintainability issue?
My lord, facts, of course, I'll have to respond in detail, my lord. My lord, we'll have section 37, my lord, because of the Arbitration and Conciliation Act. Now, this had undergone an amendment in 2019.
Yes.
It says, notwithstanding anything contained in any other law for the time being in force, an appeal shall lie from the following orders and from no others to the court authorized by law to hear appeals from original decrees of the court passing the order. Now, this is perhaps covered under B, 37B, granting or refusing to grant any measure under section 9. So the phrase used is to the court authorized by law to hear appeals from original decrees. Now,
The impugned order has been passed by which court?
commercial court, which is the Court of Civil Judge Senior Division number 1. Now, the Commercial Courts Act had again come into force, my lord, and there, if your lordship has section 10.
Yes.
Section 10, jurisdiction in respect of arbitration matters, where the subject matter of an arbitration is a commercial dispute of a specified value, and we are covered by subsection 3, my lord. If such arbitration is other than an international commercial arbitration, all applications or appeals arising out of such arbitration under the provisions of the Arbitration and Conciliation Act 1996 that would ordinarily lie before any principal civil court of original jurisdiction in a district not being a high court shall be filed in and heard and disposed of by a commercial court exercising territorial jurisdiction over such arbitration where such commercial court has been constituted. Now, if your lordship has section 13, 1(3).
Yes.
13(1). Any person aggrieved by the judgment or order of a commercial court below the level of district judge may appeal to the commercial appellate court within a period of 60 days from the date of judgment or order. Now, my lord, here commercial courts were constituted and all courts of civil judges were designated as commercial courts and all courts of district judges were designated as appellate court. So with these notifications and the coming of the Commercial Courts Act, my lord, the jurisdiction in under section 37 now lies with the district judge, being the commercial appellate jurisdiction.
No, but the appellate division of High Court also have the.
Yes, and therefore, my lord, this court had the occasion to examine that. Though it said that though there is a commercial appellate division in this constituted in the High Court, nevertheless, going by all of this, there'll be only one appeal before the district judge.
Division bench.
This is by the division bench. my lord.
No, who passed the impugn order? Which court?
Commercial court, that is the court of civil judge number 1.
Okay. Okay. What is the division bench judgment?
Yes, my lord. Paragraph 12 onwards. My lord, here again, it was sought to be argued that since there is a commercial appellate division constituted, so orders from the district judge will again lie before the commercial appellate division. That was the argument advanced here, my lord. And para 12, if your lordship sees,
Yes.
it must be mentioned herein that unlike a couple of high courts in this country, which has been conferred with original jurisdiction to try suits, including commercial suits, this high court has not been conferred with the original jurisdiction to try suits and or commercial suits. Therefore, upon a conjoint reading of the provisions of 5, section 3, subsection 1, 4, subsection 1, 13, subsection 1, and 13, subsection 1A of the Commercial Courts Act, it is clear that unless the impugned order is passed by the commercial division of this court, no appeal shall lie before the commercial appellate division of this court, notwithstanding that a commercial appellate division has been constituted and notified. Therefore, the court has no hesitation to hold that the present case is squarely covered by section 13(1)(a) of the Commercial Courts Act.
So in High Court,
Now,
the appeal lies only from High Court.
yes, my lord. And those appeals will be very few, my lord, because only there are cases under the patents law where the High Court is still exercising jurisdiction of the only those matters. So perhaps this constitution of the appellate division was, with respect, not necessary even, my lord, but therefore it said.
You have the High Court notification.
I just handed over. My lord. Yes. If I may read this is of 13th February 2019. On the recommendation of the Honorable Gauhati High Court, the Governor of Assam is pleased to designate the courts of all civil judges senior division as commercial courts and courts of district judges in all districts as appellate court at the district level under the commercial courts, commercial division and commercial appellate division of the High Court Amendment Ordinance 2018.
Yes. Mr. Alam.
My lord. Lord Lordship, can you adjourn the matter, my lord? Please reply, my lord, day after tomorrow. On the issue of maintainability.
Okay. Heard Mr. N. Alam, learned counsel for the appellant. Also heard Mr. B. D. Dekar, learned counsel for the respondent. This appeal under section 37 within bracket 1 within bracket small b of the Arbitration and Conciliation Act 1996 has been preferred by the appellant, impugning the judgment and order dated 17/2/2026 passed in missed arbitration case number 205-2024 by the Court of Learned Civil Judge Senior Division number 1, Kamrup Metro, by which the application filed by the present respondent number 1 to 6 under section 9 of the Arbitration and Conciliation Act 1996 was allowed. Learned counsel for the respondent, you are appearing for
Two and one and two. One and two.
respondent number 1 and 2
I'm on a cabin.
has slash caveator has raised the question of maintainability of the present appeal. He submits that as per section 37 of the Arbitration and Conciliation Act and appeal under said provision would lie before the court which is authorized to hear by law, which is authorized by law to hear appeals from original decree of the court passing the orders mentioned in section 37 of the Arbitration and Conciliation Act. He submits that in view of the provisions contained in section 13 of the Commercial Court Act 2015, as well as in view of the decision of the division bench of this court in the case of Messrs. NES Digboi Bogapani versus Bharat Petroleum Corporation Limited, within bracket Commercial Appellate Division, case number 1/2025, judgment dated 23/4/2025. The High Court the appeal from a commercial court would lie before the where is the notification regarding appellate division?
Appellate division notification I did not get. So that won't be relevant because ultimately it says 1A says if it's by the district judge, then it goes to the.
क्या लिखा? Would lie commercial court, that is the court of
District judge.
civil judge senior division, would lie before the district judge, and the commercial appellate division of this court would entertain appeal only from commercial division of this court. Stop. Mr. N. Alam, after hearing the submissions made by Ms. Learned Counsel for the respondent number 1 and 2 and slash caveator, seeks 2 days time to give reply to the same. Stop. Let this may win.
My lord, 26th, I have some difficulty, my lord. Can it be 27th or in April, my lord?
27th.
27th.
Let this matter be listed again on 27th of March for hearing on the question of maintainability of the instant appeal.
Item 4.
Much
Obliged.
So in this case, I have filed this MSc appeal, Lordship. Right, Lordship. In this case, the MSc appeal is filed on the ground that the father of the claimant is the Lordship owner of the vehicle. He is not a third party, Lordship.
Heard Ms. D.D. Burman, Learned Counsel for the appellant. This appeal under sections 173 of Motor Vehicle Act has been preferred by the National Insurance Company Limited, paying for National Insurance Company Limited, impugning the judgment and award dated 3/12/2025, passed by the Motor Accident Claims Tribunal, Shankardev Nagar, Hojai, in MAC case number 567/2016, whereby the appellant was directed to pay a compensation amount of rupees 5,15,760 along with interest to the claimant respondent. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. The appeal is admitted. Issue notice to the respondents and call for the records of MAC case number 567/2016 from the concerned tribunal. The registry shall take steps for requisitioning the aforesaid records. The appellant shall take steps for issuance of notice to the respondents by speed post as well as by usual mode within 7 days of date of this order, returnable on 4th of May.
And I have finally IA for stay, Lordship.
I will issue notice.
Yes, Lordship. Yes, the insurance company is not liable to pay, so interim.
No, we are not grant whether any execution has been filed.
No, Lordship.
So we are issuing notice now. I may issue notice same day.
Obliged.
46 from supplementary list.
আগৰ একো নথিং নালাগিব এতিয়া।
May it please your lordship.
No. Yes.
My friend is on KT. That may be discharged.
We're filing.
Yes, Mr. Banik. You're for all the, how many respondents are there?
My lordship.
Cavator is for,
For the respondent number 1 and 2. One, Villa.
It's for the plaintiff.
And for the plaintiff, respondent number 2 and 3 are pro forma defendants in the suit.
what was the order passed, impugn order?
My lordship. An ex parte ad interim order was passed by the learned jurisdictional court on the first day, assailing which we have filed the first appeal.
This one.
This one.
And when is the next date?
Next date is on 31st. 31st. I squarely understand, my lord, that technically appeal ought not to have been filed. Right course of action would have been to appear before the jurisdictional court and contest on 31st. I understand. But if my lord would permit me, without going into the merits of the matter for the present, 19th of February, the order was passed granting an ex parte ad interim injunction fixing on 31st.
What restraint was issued?
Entire thing. So the order, lordship finds at page 58. They're basically claiming adverse possession, and on the strength of that,
They are in possession.
no, we are in possession. That's not a problem. No, it's his word versus mine. That's not the point.
Disputed.
Not disputed. He admits that we are the owner. My predecessors are the owners. Our names were mutated. He filed the suit claiming adverse possession, rightly or wrongly, and also with challenging the mutation. Now, so far as mutation part is gone, that is there's a bar on that. I'm not on that. We are only on this point. So far as the possession part was concerned, this part was also, because it's a plea of adverse possession, requirements met or not, because ex parte ad interim on an adverse possession would require some parameters, will place the judgment. But I'm not even bothering lordship on that. If I may read the order first, and then why I am here and not before a jurisdictional court on 31st, that I have to satisfy. If I do not satisfy that, I would have no case. Because in an ex parte ad interim injunction, the right course would have been to appear before the trial court.
Yes.
Yes, and I admit this is the correct thing.
And when the next date is not too long.
Correct. Now, why we have filed the appeal? I put the question to myself and I address that issue first. My lord, 19th of February 2026.
Where is the impugn order?
Page 58. 58.
Page
58.
50.
58. May I read that order?
Yes.
May I read, my lord? This instant Ms. J case has been registered on the petition filed by the petitioner under Order 39, Rule 1 and 2, read with Section 151 CPC, paying for grant of temporary injunction against the opposite parties. The petitioner has, in addition to the prayer for grant of temporary injunction, also prayed for grant of ad interim temporary injunction. The learned counsel for the petitioner has submitted that the petitioner has a prima facie case, as he is the son of late Sridhar Tamuli, who was earlier in possession over the suit land, which was adverse to that of the original owners, and thereby he had acquired right, title, and interest over the suit land by way of adverse possession. And after his death of the petitioner, the petitioner and the pro forma opposite parties have been in adverse possession over the suit land, and they have perfected their title over the suit land by way of adverse possession. The learned counsel has submitted that the opposite parties are the registered owners, that's us, of the suit land, and have recently mutated their names in the records of rights in place of the deceased father, Chandra Das, on 30/1/2025, which was influenced by the rise of prices in around of Rang Mahal after setting up of judicial township. The learned counsel has submitted that the petitioner has received the demarcation notice from the office of the circle office, and the opposite parties have been trying to dispossess the petitioner from the suit land and alienate the same, for which grant of ad interim temporary injunction has been necessitated. I have heard the learned counsel for the petitioners and perused the case record, including the title suit and the documents filed therein. The petitioner has submitted the copy of the certificate issued by the government Gaupura, which shows that the predecessor in interest of the petitioner and thereafter the petitioner and a family member have been in possession of the suit land for 70 years. The copy of the demarcation notice issued by the circle office has also been annexed. The name of the opposite parties has recently been mutated in the records of rights. It's an admitted fact that the prices in and around Rang Mahal have skyrocketed after the foundation stone laying of the new Gauhati High Court building. In such a situation, the chances of alienation and encumbering of the suit land and also disposition of the petitioner from the suit land cannot be ruled out. The peculiar facts and circumstances of the case tilts the balance in favor of a grant of ad interim temporary injunction in order to protect and preserve the suit land as it stands today, failing which the petitioner is likely to suffer irreparable losses and injuries. In view of the above discussion, it is held that it's a fit case for the grant of ad interim temporary injunction, whereby opposite parties are temporarily restrained from alienating or encumbering the suit land in any manner till the next date. The opposite parties shall not dispossess the petitioner from the suit land till the next date. The petitioner shall file compliance report as per Order 39, Rule 3(3)(a)(b) of the CPC issue notice so-and-so, fixed 31/3/2026 for SR written objection, my lordships.
So restrained only from alienating and dispossessing.
My point was, which I was addressing here, without going into this on the merits of the matter for the present. Well, I'll address your lordships, everything will address. The order was passed on 19th of February, fixing the date on 31st of March, beyond a period of 30 days period.
Oh, then
On this,
that is the lapse.
no, there is a lapse. We've given the list of books, may I just pass on the print.
No, there is a lapse.
There is a lapse. This lapse has been held by the Honorable Apex Court in one manner. We'll give the list of books though. If I may invite my lord's attention kindly to paragraph 16(1)(6). I'll read 3-4 paragraphs. That's very essential. This would be the lapse. May I read below?
Yes.
Yes. Learned
On
Sibal-
19th February, next date was given 31st of March.
Yes. What is
Beyond,
the
beyond,
this lapse has been discussed in this judgment.
which para?
I will start from 16. I'll just skip over 16, 17. 17 if I start. It's on 39 3A. 17.
Yes.
The rule does not say that the period of injunction order should be restricted by the court to 30 days at the first instance. But the court should pass the final order on it within 30 days from the day on which the injunction was granted. Hence, the order does not ipso facto become illegal merely because it was not restricted to the period of 30 days or less. Nonetheless, we have to consider the consequence, if any, on account of the court failing to pass the final orders within 30 days as enjoined by Rule 3A. The aforesaid rule casts a three-pronged protection to the party against whom the ex parte injunction order was passed. First is the legal obligation that the court shall make an endeavor to finally dispose of the application of injunction within a period of 30 days. Second is the legal obligation that if for any valid reason the court could not finally dispose of the application within the aforesaid time, the court has to record the reasons thereof in writing. What would happen if a court does not do either of the courses? We have to bear in mind that in such a case, the court would have bypassed the three protective humps which the legislature has provided for the safety of the person against whom the order was passed without affording him an opportunity to have a say in the matter. First is that the court is obliged to give him notice before passing the order. It is only by way of a very exceptional contingency that the court is empowered to bypass the said protective measure. Second is the statutory obligation cast on the court to pass final orders on the application within the period of 30 days. Here also, it is only in very exceptional cases that the court can bypass such a rule, in which cases the legislature mandates on the court to have adequate reasons for such bypassing and to record those reasons in writing. If that hump is also bypassed by the court, it is difficult to hold that the party affected by the order should necessarily be the sole sufferer. It is the acknowledged position of law that no party can be forced to suffer for the inaction of the court or its omissions to act according to the procedure established by law. Under the normal circumstances, the aggrieved party can prefer an appeal only against an order passed under Rules 1, 2, 2A, 4, or 10 of Order 39 of the court in terms of Order 43, Rule 1 of the court. He cannot approach the appellate or revisional court during pendency of the application for grant or vacation of temporary injunction. In such circumstances, the party which does not get justice due to inaction of the court in the following mandate of law must have a remedy. So, we are of the view that in a case where the mandate of Order 39, Rule 3A of the court is flouted, the aggrieved party shall be entitled to the right of appeal, notwithstanding the pendency of the application for grant or vacation of temporary injunction against the order remaining in force. In such appeal, if preferred, the appellate court shall be obliged to entertain the appeal and further to take note of the omission of the subordinate court in complying with the provisions of Rule 3A. In appropriate cases, the appellate court, apart from granting or vacating the modifying the order of such injunction, may suggest suitable action against the erring judicial officer, including recommendation to take steps for making adverse entry in the ACRs. Failure to decide the application or vacate the ex parte temporary injunction shall, for the purposes of the appeal, be deemed to be the final order passed on the application for temporary injunction on the date of expiry of 30 days mentioned in the rule. Pausing for a moment, Milord.
What it means,
It means
last line.
19, the
Failure.
order was passed. If it was not decided or reasons not assigned beyond the 30 days period, which would be on 21st, then on the end of the 30th day, the injunction order does not survive because of flouting of 3A. So therein, the decision comes to the 8th, Milord.
Failure to decide the application or vacate the ex parte temporary shall for the purpose of appeal be deemed to be final order.
For this appeal, that becomes over on the 31st day, on the 30th day, end of the 30th day. But since the order was passed for 40 days, it already has spent its force. Let there be an inter-party order. I'm sorry. So
No.
since 19 it was fixed, it crosses 1 month period, 30 days. The Honorable Apex Court says for the purposes of this appeal, that order lapses because there is no reason
No,
assigned.
it does not say lapses. It says it becomes final order.
Absolutely. May I this?
You read again.
Deemed to be the final order on the application for temporary injunction on the date of expiry of 30 days. So this comes without hearing me.
Yes, now it
That
has,
the remedy comes. Now, because
that order shall be deemed to be final order. And now the.
43(1)(r) comes in.
Yes,
Now.
now it will be
Now I-
decided in appeal.
So if in this actual background, my 43(1)(r) is protected. Now I invite my lords to the case presented on which the injunction ad interim was granted. May I? What I was preferring is, what I was submitting with all humility is, without even considering the points on which the adverse possession is established prima facie, being absent, without even considering that my mutation is there, they are admitting obviously my ownerships and all, without even considering the fact as to who is in possession. The mutation records would confirm them, even otherwise we are the owners. There was no hurry to pass the order of.
Who is in possession?
We are in possession. We are fenced apart. We are in possession. We are in possession. There
The
can be
land is a vacant land.
no, it's our possession, it's a fenced part. There is no difficulty on that. Anyone can claim adverse possession, but to establish the pleadings would require something more on record. So we'll meet them one by one, if Lordship permits. What I was praying is that let there be an order vacating this. On 31st, we filed for, we address the Honorable Court on jurisdiction, come back again, either he or I. Let there be an inter-party order. Lordship takes up, very well. Let there be a status quo order till 31st. No problem, but let the jurisdictional court hear us. It was not a case for exceptional, where I can understand. If there was a case of dispossession of a recorded owner by a third party, I can understand that the plight. But here is a case where we are the owners and someone claims adverse possession without pleading the requirements as per law, and the jurisdictional court did not take the pain to see whether things are there or not, granted it on the basis of two factors. Number one, the price of the land going high because High Court is being shifted. That cannot be a consideration in law. Number two, that the Gauhati has issued a certificate. My lord, there is a judgment of this Honorable Court, which discusses and says the retirement age of the Gauhati is 65 years. A man who is supposed to retire in the 65 years could not have seen 70 years within possession. Those considerations were fatal to us. So we would like to have a protection. Therefore, we get hold of this judgment and come to this Honorable Court and pray that under 43(1)(r), let there be an order of status quo. Lordship may modify the order. I'm not saying against him. We'll fight it out in the jurisdictional court and then we'll come back again if need be.
Yes.
That's all.
May I please? May I please, the order absolutely requires no interference from your lordship.
No, but apparently it is against the mandate of 39(3)(a).
No party shall be made to suffer because of some act of omission of the court, my lords. I am
Yes,
also one of the parties.
you were before the court on that day.
My lord.
You could have pointed it out.
My lords,
to the
dates
court.
in the lower court, dates are given in the evening, my lords.
No,
I moved the application, but the dates was given by the court master.
No, when there is a statutory mandate that
My lord,
you are
otherwise-
agreeable to maintain status quo.
No, my lords, the possession is with me. Absolutely, my lords may kindly come, my lords may kindly come to,
No, let the trial court decide the matter. Let the trial court decide the matter. Let them file. Let them file.
the possession was with me, my lords. I was in settled possession. There are various catena of judgments regarding the settled possession, my lords. They come and they do, they get the name mutated in 2025 by way of inheritance. My lords, that is taken record of, and it has been, my lords, may kindly come to page 29. This is
No, but first you overcome this 3A, order 39 rule 3A, and the observation of the
The 39 rule 3A says that it shall make an endeavor. It's not a compulsory, a mandatory provision, my lord. Shall make an endeavor. My lords, my lords may read order 39 rule 3A.
and the judgment cited by.
The judgment clarifies what it should be. There is one more judgment which I should play, but after my friend is over. So I don't agree. But that would be relevant because in the realm of things, 2000 in I'm placing a judgment below. This one. This one is far more important. Down the line. If Lordship takes a paragraph 44 on the point, that was missing. It was totally tilted towards them for no reason at all. I understand. High Court has been shifted there. Price rise would come. Can there be consideration for lawful owner to be ousted? When he offering injunction, ex parte, that too, 40 days later you put. Now we have got over judgment and it was cannot be circumvented. Based paragraph 44, if I may read with Lordship permission.
Yes.
My lord. Usually, the court should be cautious and extremely careful while granting ex parte ad interim injunctions. The better course for the course is to give a short notice and in some cases even dusty notice. Hear both the parties and then pass suitable bi-party orders. Experience reveals that ex parte interim injunction orders in some cases can create havoc and getting them vacated or modified in our existing judicial system is a nightmare. Therefore, as a rule, the court should grant interim injunction or stay order only after hearing the defendants or the respondents. And in case the court has to grant ex parte injunction in exceptional cases, then while granting injunction, it must record in the order that if the suit is eventually dismissed, the plaintiff or the petitioner shall have to pay full restitution, actual or realistic cost and mean profit. It runs in crores. This was also absent. They cannot play hide and seek. We'll catch them up with law. That observation also had to be there. But 39.3a, it does not survive. Let us go back to trial court. We'll come back, either he or I. Inter-party orders are much better.
Submission is that, when we were moving the application on the 19th of February, they were already came with the circle office officials and they already demarcated the land on the basis of the mutation. They had encroached the property and they had fixed some bamboo sheds, which were later removed by us, and they fenced the boundary wall with wooden boundaries. And so immediately we had to move the application. We got the injunction. My lords, now 39A, now if the status quo is maintained, my lords, they will come inside the property.
So we are in the
property. The possession is us, my lords. The possession is us. My lords, may kindly come to page 29. My lords, at paragraph 11, this is our claim. We have annexed this document, but this is not a part of record before this court. My lords, that in month of December 2025, the plaintiff was served with a notice dated 30/10/2025, whereby it was notified that the suit land will be measured.
No. Now, the appellant is ready to contest the matter before the trial court.
My lords. Let them file their written objection, my lords. 31st, heaven will not fall for.
No, there cannot be an order of this ad interim exemption.
Let them take the challenge before that court.
Not in law. In the four corners of law, it's not there. Or otherwise, the 43(1) I will argue whole hog on the legal point, line by line, law by law, decision by decision. But what I'm trying to say is that
Who are the other respondents?
His brothers,
my brothers,
who are pro forma and also enjoying the same benefits as he's playing, so he's echoing for them. But that's perfectly all right for us.
You are appearing for all the respondents?
No, one.
For one, my lord. They are made the pro forma defendants in the suit, my lord.
Lordship stays the order, or here's the matter any day after serving of notice. I was not even praying for that. I was praying status quo, let us go back.
The Gaupura certificate is stated. My lord, may kindly have this page, my lord. Page 29. My lord, page 29, paragraph 11. My lord, that in the month of December 25, the plaintiff was served with a notice dated so and so, whereby it was notified that the suit land will be measured on 26/12/25. However, it was clarified therein that there won't be any delivery of possession. Well, this clear.
No, what is the difficulty on your part from?
Well, if the
grant
status
of
quo is maintained,
status quo?
they are trying because it's a vacant land.
But you are
my lord. I have been cultivating in that land, my lord, for 60 years, my lord. From my father's time, my time. The neighbors are there, everybody knows are in our possession.
Then maintain status quo till 31st. If you are in possession.
My lord, we have filed an application for order 39-2A also for the violation of breach of the injunction, my lord. After the order was passed, they have encroached there a couple of times. Now they are before this court, so they have stopped. But they have constructed various sheds, my lord. They have laid some bamboo boundaries also, my lord.
Pleadings to the extent that the one who claims adverse possession has given the land on Adi. In 71 rules, it says that clearly there must be a record of rights for things to be. One claiming
That
adverse
is a
possession
matter
cannot
of
give
evidence, my lord. That is a matter of trial.
No, this is statement or not. Absolutely, the land grabbing activities are going on. What I'm trying to since the property is in crores, now these activities are let them be status quo. Lordship stays the matter. I leave it to the lordship. Issues notice to them. Everyone comes and we argue the matter. I was on a softer pedal. Let us go and have it on
Their only claim is on the basis of mutation. Mutation does not confer title, my lord. When the title is under a cloud, possession is the best evidence, my lord. Best title.
But adverse possession claiming I can go to line by line. It has not been.
Heard Mr. N. Burnick.
S. Burnick.
Sorry, S. Burnick. Learned counsel for the appellant. Also heard Mr. N. Patiri. What is your name?
N. Patiri.
N. Patiri. Learned counsel for the caveator / respondent number 1. This appeal under order 43, rule 1 within bracket R of the Code of Civil Procedure 1908 has been preferred by the appellants, impugning the order dated 19/2/2026 passed by the Court of Learned Civil Judge Senior Division, Kamrup Amingao, in Ms. case number 85/2026 in connection with title suit number 68/2026, whereby the trial court granted ex parte ad interim injunction against the present appellant while issuing notice to them. So, issue notice to the respondents. Since Mr. Patiri has already appeared for respondent number 1, no formal notice need to be issued against respondent number 1. You have received the copies. The appellant shall take steps for issuance of notice upon the remaining respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 4th of May. I is there.
I is there. I don't know.
Will you file any objection in IE?
My lord, I will file, my lord. If there has to be a maintainer status quo order, my lord, then the correct approach would have been to file an application for vacating our stay, our injunction, my lord, or under order 39 rule 4. Well, if they file an application under order 41,
43(1) is mentioned.
Stay of the operation of the order, my lord. If the order is stayed, my lord, my injunction goes. Either they have to file an application for vacation of the injunction, then your lordship can
43(1) is mentioned. As per judgment, 43(1) is mentioned.
That is for stay of the order.
Absolutely, 41(5).
Stay of the order means my injunction goes, my lord. So order 38, so vacation, then your lordship may have ought to have granted a stay, my lord. A status quo.
Injunction 40 days.
That is my. I will file an objection to this.
He says he claims he has given an ADI. We are the recorded owners. Admittedly,
No, they are not recorded owner. They only have mutation.
Mutation. whatever, if his other brothers are there, he is not representing, it's up to his peril.
Third,
They cannot enjoy the ex parte ad interim injunction.
third
Somewhere we
point
have to be
so
there.
and so. This application under Order 41, Rule 5 of the Code of Civil Procedure 1908 has been filed by the applicant in connection with the connected first appeal against order number 22/2026. Praying for stay of operation of the order dated 19/2/2026. 19/2/2026, passed by the Court of London Civil Judge, Senior Division, Kamrup Amingaon in Ms.J. case number 85/2026, arising out of title suit number 68/2026, whereby the applicant whereby the trial court granted ex parte ad interim injunction restraining the present applicants from alienating the suit land or creating any kind of encumbrance thereon, as well as dispossessing the respondent number 1/plaintiff from the suit land before the next date fixed by the trial court. Learned counsel for the applicant has submitted that the impugn order was passed by the trial court in Ms. J case number 85/2026 on 19/2/2026. And though ex parte ad interim injunction was granted against the present appellant, the next date and notices were issued to the present appellant. The next date of the aforesaid Miss case was fixed on 31/3/2026. That is well beyond the period of 30 days as mandated in Rule 3A of Order 39 of the Code of Civil Procedure 1908, during which is the period in which the court had to make an endeavor to finally dispose of the application when an injunction is granted without giving notice to the opposite party. Stop. Learned counsel for the applicant submits that by fixing the date of appearance / filing written objection by the present applicant beyond the period of 30 days as mandated in Order 39 Rule 3A, the trial court has flouted the statutory provisions which are incorporated in the statute for protecting the interest of the party which was not before the court when the order of ad interim injunction was passed. Learned counsel for the petitioner has cited a ruling of the apex court
Yes, sir.
in the case of A. Venkata Subbayya Naidu versus S. Chelappan and others, reported in 2007 SCC 695. Wherein the apex court has observed that in cases where the mandate of Order 39 Rule 3A of the Code of Civil Procedure is flouted, the aggrieved party is entitled to prefer an appeal under Order 43 Rule 1 within bracket R of the Code of Civil Procedure, and in appropriate case, the appellate court, apart from granting or vacating or modifying, no, ये काट दीजिए. In an inappropriate case, the appellate court may grant or vacate or modify the order of such injunction. Learned counsel for the petitioner submits that the petitioners are ready to agitate their case before the trial court by filing written objection on the next date fixed. However, and in the meanwhile, also ready to maintain status quo. On the other hand, you'll be filing written objection.
Written objection to this application.
On the other hand, learned counsel for the cavator / respondent number 1 has submitted that the respondent number 1 may be allowed to file written objection against the prayer of the against the interlocutory application filed by the present petitioner. Stop. He also submits that in the meanwhile, no status quo order should be passed, as though an ad interim injunction was granted, an ex parte ad interim injunction was granted. However, same has been flouted, violated by the present appellant, and the respondent has also preferred an application under Order 39 Rule 2A of the Code of Civil Procedure for violation of the ad interim injunction order. Since the petitioner, since the respondent is intending to file a written objection, he is allowed to file written objection before the next date fixed. However, as apparently the impugn order has been passed by fixing a date beyond the period of 30 days as prescribed in Order 39, Rule 3A of the Code of Civil Procedure, which has been deprecated by the Apex Court in the judgment referred herein above. Both the parties are directed to maintain status quo till the next returnable date. The petitioner shall take steps for issuance of notice to the other respondents within a day from the date of in interlocutor application. You have to take steps within a day from the date of this order, returnable on 4th of May.
My lords, my only submission prayer is, my lords, my possession may be protected, my lord. Can it, my lords, let it be a status quo pursuant to the injunction order, my lords. My lords, now if possession is not
We
protected,
don't know.
my lord, my possession has been considered on the basis of the materials on record.
Cannot
my
be.
lord.
We are objecting on that. He's a
My lords,
KVA.
my lords, my
Cannot be. At 65
We have
is the
filed
age of
for
retirement of a Gaupura. He's banking on that process
possession
of
has to be protected.
70
My
years
status
in
quo,
possession,
he'll come
adverse
to-
possession, impossible. my lord. That cannot even
The
happen.
court has
Lordship has
recognized my
admitted the
possession,
appeal.
my lord.
Lordship has to hear me. Lordship has admitted the appeal.
No, both the parties are to maintain
Absolutely, my lord.
status quo.
That'd be a fair one. I'm not
No,
going against him.
My lords, let him give an undertaking, my lords, that he won't interfere
That's
with my possession.
beyond the scope of law. He's negotiating with me across
No,
the
no, not
They cannot-
negotiating, my lord. I have
So
an
beyond the
injunction
scope of law.
in
We're
my
not talking
favor,
about
my lord,
lordship kindly-
due to omission of the flouting of
He's
the rules of
accepting
the
it.
code, my lords.
It has to be on record below.
How am I to suffer, my lords?
Next date given.
My lords, 31st is on the date, my lord.
That
Let the
cannot-
trial court decide, my lord, the application, my lord. Till that time, my possession.
The
will
two
be
persons
protected,
are
my
also
lord.
there,
The
Lordship.
trial
You should
court has
let him
raised-
come.
Trial court has
Let him
raised
complete the
the
representation.
injunction order on the basis of my possession, my lord.
They
So-
cannot claim adverse possession and then possession and then.
No, that is
go
a
on the
matter of
record
evidence,
ownership.
my lord. My
They
adverse
take
possession is a matter of evidence.
Don't put a certificate with her. And the direct jurisdiction court did not even consider to make an
My lord, the
endeavor.
circle
See,
officer
what
has
is,
clearly
they
stated the
accept
delivery of
circumstances.
possession won't be
Let
given,
them-
my lord.
I'll leave it to your lordship, but let it be that way.
Next date is on 7th of April.
I'm deeply grateful.
My lord, my possession may be protected.
cannot.
They may encroach upon, they may come upon inside. If they are claiming possession,
They cannot have that way below. Then
No,
all
injunction
the-
was granted.
Not in this way. Both, you will also not change your status.
Status quo as on today, status quo order is there.
Let the
pray for that.
status quo be as on
He
the day
cannot have the
pursuant to the
possession
injunction
without
order,
any
my lord.
favor.
I may not be,
Cannot have a status quo written in his favor.
I shouldn't
It goes
suffer
as
because
is when it's
of the
submitted.
some date.
We cannot have
some
that.
technicalities, my lord.
We do not have a
On
technical.
the basis of materials
They
on
cannot-
record.
That could have been.
No, Mr. Banik, don't interrupt because the 2A petition is pending before the court.
My lord.
You can agitate before the trial court.
Yes, he can.
But status quo as on date, because they are claiming possession, my lord, make an observation, my lord, that the status quo be pursuant to the injunction order, my lord.
That he cannot.
At
do.
least the
We are
31st of
yours.
March, my lord.
Ex parte identity injunction was granted. They cannot have that position.
And the
But
circle
we accept
officer,
still in possession.
circle officer has clearly stated the delivery of possession won't be
This,
given.
since the next date of this appeal as well as interlocutory application is fixed after the date which is fixed before the trial court, this court will, the order passed today shall have no bearing on the trial court
Absolutely.
in passing
Two-way.
in no bearing on the trial court while dealing the application filed by the respondent under Order 39 Rule 2A before it.
Grateful.
My lord,
Obliged,
my
Lordship.
only
Obliged.
prayer, my lord, my possession, what about my possession, my lord?
Then he cannot have it that way.
You agitate before the trial court.
My lord.
Grateful.
But my lord, let the status quo observation be made, my lord.
That cannot
That
be.
be pursuant to the order
By
of the
appeal,
injunction. my lord.
if that line is comes in, my lord, he has to contest
Yes,
the merit.
definitely he has
cannot have an
suffered
appeal that
because
way,
of the
my lord.
flouting of the
For
order
41
39 Rule
to be
3A.
merits.
But I have also suffered because I've got an injunction, my
I'm
lord.
going to merits.
No
He cannot
party
have the
should be
possession
made
in his
to
favor.
suffer, my lord.
Way is there, we'll not go there. Absolutely, my lord. Obliged, Lordship. Grateful.
The possession may be protected, my lord. My only prayer is
There
there.
may not be any word in his favor.
Because the
or in my
possession
favor.
has been recognized by the trial court, my lord.
Nothing. That's a wrong. That's
It
what
has,
we are
it
under
has
the-
been recognized in the impugn order, my lord.
I have given reasons for
I'm so grateful. Obliged.
Order, item 5 and 3.
Your Lordship, his IAs have come for substitution of respondent number 1.
yes.
Your Lordship, may first take up IA 803 of 2026. Your Lordship, this is the setting aside of abatement application for substitution of respondent number 1 in the instant appeal.
How many respondents are there?
There are 2 respondents.
You are for
Both the respondents.
you are objecting?
No, your lordship.
No objection. Heard Miss A. Biani, learned counsel for the applicant. And this is IA 803. Also heard Miss K. Sharma, learned counsel for the respondents. This application, this interlocutory application has been filed by the applicant insurance company praying for setting aside of abatement of the appeal on death of respondent number 1, namely, who died? Asma Begum.
Yes, Your Lordship.
Asma Begum. The learned counsel for the applicant has submitted that the applicant, the respondent number 1, had died on
8/10/2020.
8/10/2022 during the pendency of what is the during the pendency of the connected MSc appeal number 146/2004. Why you could not file application within due time?
Your Lordship, we were informed about the death only on 2nd of February 2026.
She submits that the appellant came to know about the fact of the death of respondent number 1 only on 27/2/2026.
02, 2nd February.
Only on 2nd February 2026. And as such, they could not, and as such, it could not take steps for substituting the legal heirs of the deceased respondent in due time, and due to which the appeal was abated against respondent number 1 against due to operation of law. learned counsel for the respondent submits that she does not have any objection if the abatement of appeal against respondent number 1 is set aside. After considering the submissions made by learned counsel for the parties and the grounds stated in the instant interlocutory application, the abatement of appeal on death of respondent number 1 is hereby set aside, and this interlocutory application is allowed. Condonation petition is there.
But there's no condemnation since we have filed the petition IA within 1 month from the date of our knowledge, Your Lordship. There's only setting aside abatement and the main substitution petition.
In delay condonation petition is required, where you have to mention that it came to your knowledge.
Your Lordship, it has been judicial precedents are there which says that if it is filed within 1 month from the date of the knowledge, then delay condonation is not required, Your Lordship. As per, I do not have it right now, Your Lordship, order 22 of the CPC grants for the right to sue and the limitation period read with section 5 of the Limitation Act. It says that when sufficient cause is shown and as per the judicial precedents, Your Lordship.
No. Otherwise, apparently there is a delay. Even the appeal got abated. You have to file an application for condonation of delay, justifying the cause. This may be one cause that you came to know about the death, or you come up with the judgment.
Okay, Your Lordship. As Your Lordship pleases.
We'll take it up day after tomorrow.
Your Lordship.
Heard Miss Abiani, learned counsel for the petitioner. Also heard Miss K. Sharma, learned additional learned counsel for the respondent. Learned counsel for the applicant submits that though the instant application has been filed for substituting the legal heirs of deceased respondent number 1 who had expired on 8/10/2022. However, no application for condonation of delay has been filed by the present applicant. In preferring this application for substituting the legal heirs of deceased respondent under Order 22 Rule 4, as the applicant has approached this court within the prescribed period of limitation after the date on which the applicant came to know about the date of death of the respondent number 1. She submits that in this regards there are judicial precedents to support her contention. She however submits that she however prays for some more time to place those judicial precedent before this court. The prayer is allowed. Let this matter be listed on next Monday. 30th March.
What trouble is that?
Item 7.
Right.
I think, yeah. Go ahead, Bonnie.
Yes, Mr. Bhattacharya.
My lord, as per office note dated 10/2/2026, respond number 1 to 4 appeared, then 5 is complete, and regarding 6 has not yet been received, and LCR received. Regarding respond number 6, may I pray for allowing us to take another steps on the respond number 6.
Who is respondent number 6?
He is the
Diabetic.
driver.
Driver.
He is not a necessary party, my lord.
Liability
And
is not a challenge.
in lower court, my lord, ex party was there against owner and driver.
Oh,
Cases of 26,
before the
19
tribunal, it proceeded ex parte. He did not contest the, then we may waive the notice in appeal also.
Difficulty is that liability is under challenge. Therefore,
liability may be under owner, my lord.
When have you taken steps?
2019, my lord.
No.
2024. 24. April 24.
Let him take steps
one note.
for the last chance.
And one death may be fixed, yeah.
Yes.
No.
Heard Mr. A. Bhattacharya, London Counsel for the appellant. Also heard Ms. D. D. Roy, Learned Counsel for respondent number 1, 2, 3, and 4. It appears that the notice issued to respondent number 5 has been received by his sister-in-law. Hence, the same is held to be duly served on the respondent number 5. However, notice issued to respondent number 6 has not yet returned. The appellant is directed to take fresh steps for issuance of notice upon respondent number 6 by speed post as well as by usual mode within 7 days from the date of this order, returnable on
Death may be fixed on 5th of May or
8th
7th of
May.
8th of
8th of May. This is a case of 2016.
Let us see this time.
2016, 10 years one.
Item A.
May I please, Your Lordship? As per the office note dated, Lordship, this 2nd of March, the service is complete, Lordship. This the sole respondent, the father of the sole respondent has received the notice. This it has already been flag marked.
Your husband or wife?
I'm the wife, appellant, Lordship.
Hearing item 37 from supplementary list.
May I pray, Your Lordship? Lordship, due to some personal difficulty, my senior has to leave the court early. So, Your Lordship, if Your Lordship may kindly take up this matter tomorrow.
otherwise I was ready.
You are with the answer to the query which I posed yesterday.
Yes, Lordship.
Whether, what was the provision? Order 8,
Order 1, Rule 8, Lordship.
Order 1, Rule 8 is applicable.
Lordship, the question was, Your Lordship, whether the suit is filed as a representative capacity.
Yes.
Whether the plaintiff has filed the suit in a
Representative capacity.
and whether. So Your Lordship would kindly take up the.
No, I am not going.
Okay.
They are praying for it.
Okay. No,
Yeah.
Lordship, if Lordship peruses the cause title of the appeal, it is read as on the death of the legal heir, on the death of so and so. It is the secretary to the committee who has substituted himself. So that itself says that he has not filed the suit in an individual capacity.
if your lordship would see the cost cycle of this case, of the
Okay, we'll take it up on some other day. Heard
tomorrow lordship.
tomorrow. No, day after tomorrow. Heard Mr. What is your name?
Imperial lordship.
Imberia Learned Counsel for the. This is item number. Imberia Learned Counsel for the appellant who submits that due to some personal difficulty, the learned counsel for the appellant, Mr. K. Sharma, had to leave the court early and therefore he seeks a short accommodation. Mr. M. K. Das,
No, lordship, P. Decca lordship.
sorry, Mr. P. Deka, learned counsel for the respondent, does not raise any objection to the said prayer. Hence, the prayer is allowed. Let this matter be listed again on 26th March
The first item of the hearing.
as a part heard matter.
First item of the hearing.
In part heard matter, stop. The said item shall be taken up as first item in the hearing column.
Much of. I'll leave it.
Item 11.
May I please your lordship?
Some query was posed to you. You are ready?
Yes, I am ready, lordship.
What was the query?
Lordship, regarding definition of governor, Lordship.
Yes.
Lordship, in Motor Vehicle Act 1988, section 145 of subsection B, Lordship, certificate of insurance covered the
145.
145 B, Lordship.
Section or rules?
Section, Lordship.
Lordship, the definition sections,
Definition.
145 subsection B. The definition of certificate of insurance includes the term cover note.
The Supreme Court had also held, Lordship, regarding clarified the definition of governor in 2008-9 SSC 133, Lordship. In
Yes, for 145B. What it says?
Lordship,
145B
Lordship, certificate of insurance.
means that. Read, please read.
May I read, Lordship?
Yes.
Certificate of insurance means a certificate issued by an authorized insurer in pursuance of section 147 and includes a governor complying with such requirements as may be prescribed, and where more than one certificate has been issued in connection with a policy, or where a copy of a certificate has been issued, all those certificate or that copy as the case may be, Lordship.
So cover note is the part of insurance,
Lordship.
certificate of insurance.
In Lordship, Apex Court also held, Lordship, that cover note in the certificate of insurance, Lordship, covers the cover note, and it definition covers in the purview of such, Lordship.
That means
in-
cover note is included within the definition of
definition of
certificate of insurance.
in this context also, I will rely upon National Insurance Company Limited versus Avoy Singh, Pratap Singh Waghela, and others, Lordship. Hi, Lordship. Lordship, in this case, I will rely upon Lordship para number 12 and 17, Lordship.
Before that, can you refresh the memory? What was the case?
Actually, offending vehicle was purchased under the under a
Scheme.
beneficiary group by availing the subsidy from the agriculture department. In the transfer certificate, Lordship,
Registration
name-
certificate.
registration certificate, director of agriculture name was shown, Lordship. Pursuant to that, Lordship, we have already MOU with the self-help group, Lordship. And after that, Lordship, the self-help group insured the vehicle with the respondent number 4. But accordingly, they have go through the procedure and issue a cover note, Lordship, on 2/5/2012. Accident was occurred on 3/5/2012, Lordship. And cover note covers, Lordship, 2/5/2012 to 1/5/2013, Lordship. And it was in the cover note, it mentioned this mode of payment was by cash, Lordship. After that, Lordship, although this issue was discussed in the trial court, but they have not considered the cover note pause because the insurance company has denied that they have issued a cover note, and they are silent about regarding issuance of this cover note, Lordship. And the problem is that, Lordship, in the cover note and insurance policy, the self-help group was issued on behalf of them, Lordship. That documents does not have any related to us because of we have not the custody of such documents, Lordship.
But your name has been shown as owner.
Registration, okay, RC, our name was shown that
In the insurance policy,
insurance
who has been shown as insured?
Lordship, self-help group, secretary and president, self-help group. But they have not as a party in the main suit, Lordship. And that is why, Lordship.
And the tribunal directed you to pay.
Lordship.
Why?
Because RC was in our name, Lordship. That's why.
No, why did not ask the insurance company to pay?
Because they after that, Lordship, they have issued a insurance certificate, Lordship, and the date of insurance was later on, Lordship.
Lordship, the
No.
insurance policy did not cover the date of accident. The cover note covered the date of accident. But the cover note
fact-
was not made a
Okay.
part of the record of the on a tribunal.
Because we
They are pressing it now. The cover notice is being pressed now. So it was not exhibited before the learned tribunal, Lordship.
but Lordship,
An insurance company is not contesting this appeal.
we have taken justice service and they have to be informed, but they have not represented in the appeal, Lordship.
As Cholamandalam and General Insurance Company, Lordship. They have not appeared.
Lordship, Supreme Court had held that the insurance company cannot issue a insurance policy to a future date. Lordship, in this context, I referred, Lordship.
What was the dates of cover from which the insurance policy becomes effective?
Lordship, in the insurance certificate, they have mentioned the cover note, Lordship, but they have mentioned that proposal was sent to 11/5/2012 and it covered.
What was the period of coverage?
May I, Lordship? Lordship, the coverage of the insurance policy was from 12 May 2012 to 11 May 2013. Yes, 12th of May 2012 to 11th of May 2013.
Lordship, the date of accident was
Third.
3rd of May 2012. And the date of the cover note, date of start of the cover note is 2nd of May 2012, just 1 day prior to the accident. Somehow it covered 1 day before the accident. So, and the cover note.
Now,
comes
why
very
there is
right-
discrepancy between
Lordship.
cover note and
Lordship, the cover note is a temporary, it is, if your Lordship may kindly see section 146. Necessity for insurance against third party risk. So no vehicles cannot be applied, Lordship, on the road without an insurance policy. So when a new vehicle is purchased, if an insurance policy document could not be prepared in a short period, a cover notice issued so that the vehicle gets insured for registration before the RTO. That is the single purpose of issue of a cover note. It is it's just a temporary document. Lordship, issued by
no,
an
but the
insurance to
cover
provide
note is
immediate.
not before the court.
Lordship, cover note
Be-
is officially not, it has not officially been exhibited, but
Mm.
a Xerox copy is in my custody. With
But
them also.
because, this cover note was custody on the Lordship with the self-help group Lordship. They have not made a party Lordship. That's why they could not produce before this honorable court.
Now, where is the cover note?
We have somehow managed to Lordship in Annexa 4, page
No,
number 34.
no,
Lordship.
but that cover note is to be
Original
produced
cover
before
note.
the court in accordance with the procedure. Order 41, Rule 27 application has to be filed. You have not filed. If you want to adduce any additional evidence at the appellate stage, the law is there. You have to follow that. Otherwise, this court cannot take cognizance of any such document.
I'll produce Lordship. The original copy. Lordship.
Yes.
Lordship,
Lordship, may I allow to
we have a copy for photocopy that was also before the trial court, Lordship, but it was not exhibited. It's a very vital document. That's why the trial court put the obligation on them, Director of Agriculture, to pay the compensation. Lordship, otherwise, they are the named owners of the vehicle in the RC as well as Form 54 accident information report. Only the policy, insurance policy was issued in the name of the agent, that is the self-help group. So that is the discrepancy, and now they during trial they had contested that why the self-help group was not made a party, because the insurance policy was issued in the name of self-help group. But Lordship, the claim was filed on the basis of accident information report, which named the Director of Agriculture as the owner. So the claimant part is not wrong.
Now you want to file any application?
Lordship.
Heard Miss G. Bora. We are giving one chance. Heard Miss G. Bora, Learned Standing Council Agriculture Department, appearing for the appellant. Also heard Mr. S. Saha, Learned Counsel for respondent number 1 and 2. One and two. Learned Counsel for the appellant submits that the appellant is relying on in this appeal on a cover note which was issued by the insurance company while issuing the policy of insurance to the insurance in respect of the offending vehicle. She submits that the appellant intends to bring that document on records and accordingly seeks leave of this court for some time to file an appropriate application in that regard. The prayer is allowed. Let this matter be listed when
After viewing the Lordship.
on 24th of April.
After, possible after 24 Lordship, as of the
May 1st.
May 1st.
4th of May.
Item 12.
Well, please the Lordship.
Yes.
My lord, today I am not ready, my lord. It will be on after 2 weeks, my lord.
Who is for the other side?
Since last 4 date, since 17/11/23, they are not appearing. That's why my
Okay. Heard Mr. S.S. Day.
no, A Bhattacharya, my lord.
Heard Mr. A. Bhattacharya, learned counsel for the appellant. None has appeared for the respondent. However, learned counsel for the appellant has sought for an adjournment on the ground that he is not feeling well today. Considering the ground stated by the learned counsel, the prayer is allowed. Let this matter be listed on 12th of May.
Alia, but
Item 13.
Yes,
Lordship, it may be adjourned for the day.
why?
Already we had a hearing matter my senior has done, but he just instructed me to just adjourn for the day. Prayer for adjournment.
Yes, Mr. G. Heard Miss S. Mushahari, learned counsel for the appellant, who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. Also heard Mr. G. Uddin, learned counsel for respondent number 1, who does not oppose the said prayer. Hence, the prayer is allowed. Let this matter be listed. 14th of May.
Nice.
May. May it hardly someone, I think, because my lord.
No, there are Bihu vacations in between. There,
15 and 16.
Organize.
no, this, there are tagged matters.
Tag matters.
One of the matter is yet to be
Even
registered.
admitted.
No,
Actually, that we have withdrawn, we had filed one appeal and the claimant had filed one appeal. And then Lordship, in that, we filed our cross objection and we have, closed with the, we prayed for closing the hour appeal. That is 16, item 16. And that's why the cross objection is, but somehow Mr. B.K. Jain was there earlier.
No, he was
before
earlier.
Mr.
Now I have
Huh.
come. Now
So
this.
he prayed,
No, you
he prayed that that appeal be tagged and be numbered. So that's why it is there. Otherwise, if Lordship will.
but
take
that
up-
appeal has not yet been numbered.
That's why Lordship, if Lordship looks at the order, it is already closed. But it was tagged because we have filed, our cross objection is exactly on those same grounds.
The
That's
cross
why-
objection they have filed in this case itself.
Huh, this
That
case.
ground. Basically, our case was for enhancement.
Then this item number 16 is
Not necessary.
not necessary.
As per my case, your lordship, in my case, they have already filed the cross objection. We
Yes,
can, your lordship can deal with that on that case.
yes.
So here, my case is for only point of enhancement. And my learned friend has filed the cross objection for the, with regard to
Where is the order regarding 16?
16.
It is in that.
Item number 16, some. Item number
Company
16.
policy, he has to.
No.
IA,
No.
IA 4378.
Case is longer, but
Oh.
they have also appealed in the trial. Initially, the case was filed against him. He appeared and said that policy is not ours, it's the policy of Oriental. Thereafter, he.
No,
they
they
have
did
been
not
stuck.
say, they
Yes,
did not
I have
say.
got the affidavit. That was of the WS that was filed before the trial. I have got that.
That is owner file, not
No,
ICS.
that was- I'll show you.
Instruction लगेगा ऐसा नहीं मत BST policy से कर
আপনি ইনস্ট্রাকশন হিল না ফোন করেছিল তাৰপিছত থাকি গ'ল আৰু এইটো লোৱা নহ'ল আপোনালোকৰ এগেইনষ্টে ফাইল কৰা হৈছিল ICICI লম্বাৰ্ডে ক'লে যে এইখন আমাৰ পলিচিয়ে নহয় অৰিয়েণ্টেল ইঞ্চুৰেঞ্চৰ পলিচি ভুলকে আমাৰ নামটো আহিলে তাৰপিছত আপোনালোকৰ নাম কাটি দিলে আৰু তাৰপিছত আপোনালোকে তাকে সেইটোৱে
Then this 16 delay condonation application, this has to be dismissed on withdrawal. Your,
Yes, Lordship, but
But
the
no.
DK Jain wanted that it should be tagged. in the
no, why
video.
it should be tagged?
I do not know, Lordship. That was his submission and the code.
Who is
He
appearing?
was appearing for the claimants
at
earlier
that
before
time, I
Mr. Manna.
think BK Jain was the counsel
Was for the claimant.
Yes, now
It was not his appeal.
No, it was
Now,
not his.
It is your appeal.
My appeal.
You don't want to pursue it because
Because
of the cross objection.
Yes.
Because same.
Then we'll
condition-
dismiss it today.
No issue.
At least. Otherwise, later on, it will bring confusion only.
It is bringing confusion on every day. Lordship.
It will show.
We want-
Item number 16. IA 4378/2018. Heard Miss R.D. Majumdar, learned counsel for the
তেওঁলোকে কৈ আছে আপোনালোকৰ
applicant.
আমিও কৈছো, owner-ও কৈছে,
Also heard Mr.
তাকে বিচাৰি আছো।
Y.S.
দেখিছিলো,
Mannan,
ক'ৰবাত দেখিলে
learned counsel for the claimant,
মই তাকে চাই আছো।
respondent. Stop. Miss R.D. Majumdar, learned counsel for the applicant, has submitted that
আমাৰ
though this interlocutory application has been filed by the applicant insurance company, that is Oriental India Insurance Company, applicant Oriental India Insurance Company,
Intel Insurance Company.
Oriental Insurance Company Limited, praying for condonation of delay of 204 days in referring the connected appeal, whereby the present applicant has impugned the judgment and award dated 9/1/2018 passed by the Motor Accident Claims Tribunal, Borpeta, in MAC case number 489/2013, however, she submits that in the meanwhile, the applicant has already filed cross objection in the MAC appeal number 365/2018, which was preferred by the claimant against the same judgment and appeal, judgment and order dated, judgment and order, that is, the judgment and order dated 9/1/2018. Stop. Learned counsel for the applicant therefore submits that the applicant now, in view of the aforesaid circumstances, does not intend to pursue this interlocutory application as well as the connected appeal. Accordingly, this interlocutory application is dismissed on withdrawal. The connected appeal is also dismissed. Now, what is,
MSc appeal 365 year also, that is my appeal.
yes,
In
And
this
cross-
appeal, we have come for enhancement of
Putul.
the award.
cross objection 18 দিব Yes, are you ready? Both of you.
My lordship, I'm not ready.
I'm ready.
For one reason, lordship, I was under the impression till a few minutes back that there is absolute liability against Oriental, there is nothing against me. Because I was not aware of the year, lordship, cross objection or a
Cross-objection.
year.
In
Now,
cross objection, they have shifted burden to you.
No,
yes, lordship.
actually what happened, Lordship, the
So
case
I
was
had no
heard.
material to
The
suspend.
case
Let
was
me,
heard
let
in
me, let
detail,
me
Lordship,
post it.
by the claimant as well as on my part by Justice P.J. Chakia. Then it was found that we said that there is no policy issued by us and we argued on that line. And then the court found that, page 88 and 18. And I'm not 18.
Anyway, your
Uh-huh.
lordship,
Lordship, then an order was passed by this honorable court on
to implead you.
8/2/2024 to implead ICICI. And then the
Mr.
appellant,
Goswami is defending ICICI.
ICICI. Then the appellant filed one interlocutory application, Lordship, by which was allowed, Lordship, and
Have been
yes,
implemented.
they have
they have
been
been
impleaded.
implemented. Then
Now, I
it
have
was-
been engaged as a counsel in this case, your lordship, to argue the matter. My case is, there are cross objection part plus my part. I'll just make a, just since my learned friend is not ready, I may not go beyond that, but only thing is that enhancement part. We are basically on enhancement. They say the policies of ICICI Lombard and in the trial court, initially the case was filed against ICICI Lombard because in form 54, in the form 54 which was submitted,
No, the Oriental Insurance Company's ground is that we are not the insurer.
they say that. They say
It
that.
is insured.
See that
Well,
form
let me-
54
Let me complete it.
Lordship is looking.
Let
at
me,
the
let me,
petition
let
as
me
a
complete
ticket.
it. Why I
No
am saying
issue.
that?
We can-
Initially in form 54, the policy number was given and the name has been stated as ICICI Lombard. I have gone through the records.
Hmm.
Then that was the ground. The case was filed in the MSCT against ICICI Lombard.
Then why award was
And then
passed?
that is the reason. Your lordship, what happened? When ICICI Lombard came, they were not a party at that point of time, Oriental Insurance. ICICI Lombard came. They filed the WS here. In the WS, they specifically mentioned that the so-and-so policy number is not of ICICI Lombard. It is of Oriental Insurance Company. Then, your lordship, the policy also, in the heading of the policy, it is Oriental Insurance Company. But in the pad of that pad where it was printed, has ICICI Lombard written above. And so ultimately what has happened, this policy was taken before the DTO, and the DTO as well as when you nowadays, your lordship, we can get it through internet. If you put on the car number, engine number, etc., chassis number, the policy and everything comes out, the numbers. In that, in fact, in the owner of the car has come up and said that this policy of Oriental Insurance, we have done it by Oriental Insurance, this is the policy, this is the everything he has given the original document. That was the reason. Then Oriental Insurance, they have been struck off. Oriental Insurance came into the scene. Now, after that, everything went on, your lordship. The matter was this. They appeared, Oriental Insurance appeared, they filed their WS. In the WS, normal denial were there. Nothing specific stated against that this policy is not of theirs. It went on. Ultimately, award given. My challenge was basically on the award part of calculation. Multiply was not correct. It is wrong. That I will come. Now, then again, when this matter was filed earlier, whoever the counsel was, he filed the case, and at that point of time, they filed a cross objection where they have annexed one document where this policy number is different. Policy number is different. Yes, the chassis number and the engine number are different, but that particular policy was issued in the name of the owner of this vehicle. That owner came before this honorable court, filed their affidavit, it is there on record. He said that is not the policy, this is the policy. I have gone through that policy, which has been annexed in the cross objection. Which policy is actually, your lordship? Date are same. Both the policies are date are same. But in that policy, your lordship, was issued subsequent, at least about 15-20 days after the policy was issued. So there is a discrepancy there, number one. Number two, your lordship, that policy number, if we go and click it in internet with the chassis number and the engine number, then it shows that it is a 12-wheel truck of Nagaland registration.
which they have. That is why, your lordship, this is a car. There was an accident. The petitioner was in, the appellant was in a bike. The car has come and hit from the behind, and the petitioner ultimately died. And this, and ultimately there was a calculation about 32 lakhs was granted. He was an NG. No problem. No, there was no objection as such. Now they are coming up with that particular policy. Your lordship will see that is on record, saying that this is the policy, and we are, that policy is also Oriental Insurance, but that is in, though it is in the name of the same owner, but this is not that particular car, which has the Form 54, the police report, everything says that the car is a small car, and sorry, it's a pickup truck, and the pickup truck number is so and so, number has been given, the chassis number, engine number, everything has been given. Only because of that fact, your lordship, this matter has been hanging for so long. And subsequently, I don't know what they came after filing the cross objection. The court also directed that yes, you make ICICI Lombard a party. They have nothing to do in this matter, your lordship. Their affidavit, I have got a copy of that. This is basically the case. Since you're not ready, I'm not arguing.
How much time will
that is
you
it.
require?
I'd like to go
Let
to
you-
the entire records because I'm a little, I've been updated by a lot of.
Yes, this is yours. We see this. It is the record, from the record I have taken.
Just 2 weeks.
I'll
I'll just see your records.
Yes, sure, sure.
I've been taken by surprise today with a lot of developments.
Anyway, since I'm not against that, but I'm just pointing it out because he's also, he should know that we have nothing to do in this case. Because they were made a party in this case. That likha hai aisa is. Why not?
In
Thanks for it.
MAC 365/2018 and cross objection 18 common order ho. Heard Mr. Y.S. Mannan, learned counsel for the appellant / claimant in MAC appeal number 365/2018. Also heard Ms. R.D. Majumdar, learned counsel for Oriental Insurance Company Limited, as well as Mr. R. Goswami, appearing for ICICI Lombard
ICICI Lombard
Insurance Company.
the Oriental Hall.
Stop.
E policy number.
Mr. R. Goswami has prayed for an adjournment on the ground of his personal difficulty, to which the other councils have not objected to, hence the prayer is allowed. When can we fix the date at the new? 12th of May.
Can it be a little bit earlier, your lordship?
Earlier, we will have difficulty. We have already fixed cases. 12th of May.
How is that?
Yes.
Let's go to the records then.
He will take the instructions and whatever is.
List accordingly.
Alia obliged.
Item 17.
Applies.
Lordship, it will take time, 17 also. I think now any hearing.
Oh,
No, you have come, but it will take time.
don't have
We do
time.
not have time.
I'm for the.
Hey, time pussy jao. Himan ki nahi time no.
Yeah, I'm for the, my lord, victim, my lord, there's a claimant. And cases, my lord, pending since, my lord. Long, my lord,
What
date
is the
may
matter?
kindly fix, my lord,
But no
otherwise,
issue.
the body is not be
Ready for date. No,
Yes, yes.
it's here out of.
A date may kindly fix and matter may be, my lord, and on fixed date, my lord, matter will be made, taken as, my lord, first item, my lord. Whereas, in hearing list, my lord, as first item. Otherwise, my lord, in since long, my lord. Huh?
That will never happen.
Huh?
If you try to fix it up on a particular date with
Yes, yes.
as first item.
Yes.
You want particular date also?
Time also.
Yes.
Time also.
Otherwise, my
In
lord,
fact, Lordship,
victim,
if
my
we
lord,
ask everybody
another, my lord,
to have their.
she has to
cases
undergo,
first time.
First item.
she has to undergo another, my lord. There's a remove her clips, my lord. There's an affixed on her body, my lord. The claimant's body. That's why she is suffering since long, my lord. That's all,
14th of May.
my lord.
14th of May.
My-
On that,
My lord.
heard Miss R.D. Majumdar, learned counsel for the petition
Appellant.
appellant. Also heard Mr. S. Hawk,
Yes, Ahmed.
S. Ahmed, learned counsel for the respondent number 1,
My lord.
as well as Mr. A.K. Chaudhary,
Respondent number 3.
appearing for respondent number 3. This matter could not be taken up for hearing due to paucity of time. Let this matter be listed on 14th of May.
Highly obliged.
On that day you mentioned.
My lord, obliged, my lord.
18 also, I think, Lordship, same order. Is also for hearing. 29 what? To me.
18 also same order. Who is for the respondent
I am for the
18?
respondent. Ship.
18 same order. What is your SI Akan?
Yes.
R.D. Majumdar and SI Akan. Baki Eke order.
Lordship, can it be possible in earlier?
Earlier not possible.
Okay. 14.
Item 20.
So,
Lordship, the appellant is the claimant here, your lordship, and the award was saddled upon the owner of the vehicle who is not participating in the, who has not participated in the trial as well as in the appeal, your lordship. The ground for appeal is that it ought to have been saddled on the insurance company and maybe pay and recover would have been awarded. That is a primary ground.
You are the claimant.
I am the claimant, your lordship. That is the urgency. This trial. The case is of the year 2016, your lordship.
How much time will you take?
Will take,
You can start. We'll continue it day after tomorrow if you start.
that can
day after tomorrow, Lordship.
No, otherwise it will not come day after. Otherwise it will come in the month of May.
lordship, I can start 15 minutes.
He
early.
can start, Lordship. I'll do my part there.
Then other councils may not wait.
I have only request, my lord. Item number 30. Item number 30.
You are from
I'm from Calcutta.
Calcutta.
So if that can be fixed on 21st of April, you know, because
Item number?
item number 29.
Let
Item number 30, my lord. If your lordship kindly accommodate 21st, 22nd or 23rd, any day, my lord. 21, 22, 23rd of April.
item number 30. Item number 30, same order due to paucity of time.
21.
Let this matter be listed on
21.
14th May.
14, then, my lord, 26th, 25th, I will come, my lord.
26th May.
May.
Okay, 26th May. Yes.
Yes, my lord.
29.
Item number 29.
Is for hearing. So he lots.
Yes. Due to paucity of time, this matter could not be taken up for hearing. When can? 14th of May. 14th
Can
May.
it be 12th?
12th May.
Lordship, may I
Lordship.
pray for a date in item number 32.
Great.
Lordship. Fix date in item number 32.
32.
Yes, Lordship.
Putul. Dates delay any can so that we can take it up. हमें जाते लोगों का ठीक okay. Yes, Mr. Agarwal.
Lordship, 32, item number 32. May I pray for a fixed date, Lordship?
Item number 32, 14th of May.
As you got 33 and 34, my lord. I am for the claimant, my lord.
33, 34.
Yes.
19th May.
Wait,
Yes.
Lordship,
Lordship,
Lordship, I want the fixed date in item number 24.
Yes, you miss.
Item number 25, same.
25.
Lordship may kindly fix the date.
Item number 25, give a date. 19th May. Yes, yours.
24 year lordship.
24th. 19th May.
Much obliged.
Lordship, item number 23, Lordship. Lordship, I pray for a fixed date and if possible, the top of the hearing, because my lord, why I am submitting so, my lord?
No, we'll
In
give.
spite of that depositing 75%, my lord, I was not allowed to withdraw it by raising objection that the tribunal directed pay and recover. She has objected that and said that as the matter is fixed for hearing,
It can be disposed of, my lord.
19th May.
But if it possible, my lord, it was,
19th May as first hearing item.
and my lord, also, my lord, in the cross objection, my lord, during the pendency of this, my lord, appeal, my lord, the respondent number 1 claimant died. Thereafter, my lord, her legal heirs were substituted. In the MSc appeal, my lord, their names have been recorded. I have checked. In the cross of objection, my lord, their names, though, my lord, there was an order, but it was not corrected by registry, my lord. At least that much reflection is required in cross objection.
Third, Mr. M. Datta, learned counsel for the appellant, also heard Ms. R.D. Majumdar.
I am
Learned
for the, my lord, respondent in MSc appeal.
learned counsel for respondent, also heard Ms. R.D. Majumdar, learned counsel for the appellant. Due to paucity of time, this matter could not be taken up for hearing. Let this matter be listed on 19th of May as the first hearing item. Learned counsel for the respondent submits that in the cross objection, in spite of order dated
14/5/2025.
14/5/2025,
25.
there is no order in cross.
No, my lord, that is the problem, my lord.
No,
Because, my lord, in the, all orders have been passed in the MAC appeal, my lord.
Make it please. In spite of order dated 14/5/2025,
2025. Passed in IA Civil 3853.
passed in IA Civil 3853,
3853/2024.
2024. The legal heirs of
Cross objector, my lord.
cross objectors were not
Made as party in the cross title, my lord.
no, but you have to file the memo of, because that was the direction. Amended cause title.
I can.
Legal heirs of the cross objector have not yet been reflected in the cause title of the cross objection. The cross objector is directed to file a amended cause title in the cross objection, reflecting the names of legal heirs of cross objector in pursuant to the order dated 14/5/2025, passed in IA Civil number 3853/2024 before the next date fixed.
Wait, please, your lordship. Your lordship, in item 28, a fixed date. Pray for a fixed date, your lordship.
Item 28, 19th.
Your lordship, can it, a shorter date?
No.
Oblige.
Yes.
27, item 27.
27th.
Any convenient date?
19th
19 May.
May. Mr. You have to also take a date
Lordship.
because now no time.
Lordship.
BJ Mukherjee, how much, what was the item number?
Item 20.
20. Name, had Mr. BJ Mukherjee. Also had Mr. R. Goswami, learned counsel for respondent number 1. You are appearing for?
Number 4.
As well as Ms. S. Mushahari, appearing for respondent number 4. Due to paucity of time, this matter could not be taken up for hearing. Let this matter be fixed on 19th of May.
Problem.